A devastating blow to the ULEZ rollout scheme was handed down by a tribunal yesterday, where it ruled that certain ULEZ signs were unlawful, and that's what I'll explain in this video. The ultra-low emissions zone as a whole was ruled lawful by the High Court back in July, which sees drivers charged a fee of £12.50 per day, else face a fine. But this latest tribunal ruling might have devastating consequences for every fine that has been issued, potentially every fine that's been issued, and I'm going to explain why. If we move to the case of the tribunal yesterday, this was a case of a scaffolder called Noel Wilcox from Hertfordshire, who was hit with £11,500 in fines under the zone for driving a truck to and from his depot in northwest London. Now, Mr. Wilcox said that he refused to pay these fines and took this appeal to the tribunal because he argued that these signs did not comply with the law, saying that they should warn drivers if they're going to be charged. Now, if you've watched my channel for any length of time by now, you'll know that I always tell people that every sign should be clear, every sign should be fair. Even whether you're a consumer or a business, the signs should be fair. Even more so if you are a consumer. The sign should tell you what you're going to be charged, when you're going to be charged, how and why you're going to be charged, and the rules that you've got to comply with if you are going to be penalised for breaking those rules. Now, in any such case like this, I also say that you should keep the evidence of anything that you might want to prove in court later. So if you fall into that category, whether it's parking somewhere or driving through one of these zones, why don't you check out our app Profify, which I'll link in the description below, where you can snap the evidence. It will take a time and date stamp and geolocation, save it all there, and if ever you need to go to a tribunal, court, or appeal anything, you can have the evidence at your fingertips. Yes, you can store it in photographs and store it on a drive somewhere, but this will keep it in a neat little case file that we as lawyers always want to see. It's one of the biggest things that we see missing when people come to court, is the lack of evidence. So check out Profify, linked in the description below. But as for this tribunal case, this scaffolder took this case to the tribunal, arguing that these signs were not lawful because they did not provide adequate information on the charging scheme, and therefore no penalty and no charge should be payable. The tribunal ruled that there was no evidence as to either the low emissions zone signs being compliant or on the adequacy of the information contained on those signs. After all, if we do a quick Google of those signs, you can see, for the most part, these signs just tell you that it's an ultra-low emission zone. I have to agree that when I first drove into London to see these signs for the first time in person, I was a little bit surprised that there was no information on these signs whatsoever. And as I say, if you've watched my channel for any length of time, you'll know that these signs are supposed to be absolutely clear. So back to the tribunal ruling. The tribunal ruled, in these circumstances, I cannot be satisfied that the low emission zone signs are authorised and lawful. Transport for London have therefore failed to establish that the contraventions occurred and that the PCNs, the penalty charge notices, were lawful. I therefore allow the appeal and direct that the PCNs be cancelled. Mr. Wilcox said that other motorists should appeal against their fines, adding that he believed that Mark Harper, the Transport Secretary, could intervene. He approached Howard Cox, the founder of Fair Fuel UK, with his ruling in an effort to encourage more people to appeal. Transport for London, Mr. Cox says, have been unequivocally told in this London Transport Tribunal ruling that the existing low emission zone signage is unlawful, which must mean the latest new ULEZ signs cannot be legal either. As you'd expect, Transport for London are trying to convince us all that they are in the right and that the signs are legal. Nick Freeman, aka Mr. Loophole, has also jumped in on this and said that he believes the signs do not comply with the regulations either, but says while Noel's victory is not binding on other courts, because it's a tribunal ruling on this particular case, I believe the case can be used by other drivers hit with penalties and fines to appeal. He says because this was a hearing at the first level, it's not legally binding. It's what's known as a persuasive, which means it can be used in other cases. And what this essentially means is if you have a similar penalty charge notice for driving through one of these zones without having paid the said fee, you could use this tribunal ruling, which is not even yet available on my legal databases because it literally happened yesterday. But when I get hold of it, I will send you a link to it. I might even draft up a template appeal for you to use this tribunal ruling as a persuasive argument that your PCN should also be cancelled. If you do want that template, please do subscribe here and like this video, share it with somebody and ask them to subscribe to this channel as well. And I'm trying to grow my Twitter or X account, my Instagram account, and indeed my TikTok account. So please go and follow all of those as well. If you want these free template guidance documents from me on here to challenge your PCN based on this tribunal ruling, I will put together for you a persuasive argument based on a given set of circumstances, and if and only if your case fits those circumstances in your view, not that it would be legal advice, but if you believe that this would fit your circumstances, then you are welcome to use it and tailor it according to your own needs and challenge your PCN, your penalty charge notice. And based on this tribunal ruling, albeit a tribunal at the first level, not binding on other courts, it would make for a persuasive argument, because what it means is that a tribunal, a finder of fact, and an adjudicator has already ruled on a given set of circumstances based on certain signs, which probably look a little something like this, because I believe most signs look like this, and most of them don't have any information on them at all about what you are going to be charged and when, or at all times, as some of them say, according to this one here. So if they all look like this, there is a strong possibility that a further tribunal or a court would believe and agree that these signs are not lawful because they don't provide you with enough information. Much like if you are challenging another road sign, which is either unclear, obscure, missing certain details, or the line markings have been eroded, or they're covered with leaves or snow or something else. Any one of those number of different reasons could potentially be used to challenge any kind of penalty charge notice if the signs were not clear, the lines were obscure, and all of those kind of things. But as for this one, if the signs did not have enough information on it, it has, by this tribunal, been ruled as unlawful. And you could use that as a persuasive case in other challenges. So as I said, if you would like some template appeal documents such as those, not that they can be a replacement for legal advice, I'm obliged to say, but I am happy to do those so long as you do me the favor of subscribing to my channel, subscribing to my other socials linked in the description below. And of course, you have my thanks for watching, and I'll see you next time.